Hello there, welcome back to Weekly Analysis Indian Courts. This is Sanya. So what made headlines in the courts of India in the week commencing February 7, 2021? Let's check out the Supreme Court first. Belonged to a family of great leaders like Hamid Ansari, former Vice President of India, gangster Mukhtar Ansari told the Supreme Court in his affidavit. The top court was hearing the UP government's plea seeking transfer of Mukhtar, accused of allegedly shooting down a BJP MLA in 2005, from Rupnagar Jail, Punjab to Ghazipur Jail, Uttar Pradesh. The Punjab government has defended retention of the accused. The Solicitor General submitted before the top court that it was indeed surprising that the Punjab government was supporting a terrorist and that identical contentions had been raised by the government as well as by the accused against UP government's petition. So what to expect in the next hearing? The bench has adjourned the hearing to February 24, 2021. Investigations will continue in FIRs filed against Rajdeep Sardesai of India Today, Mrinal Pandey of National Herald Group, Shashi Tharoor Congress leader, Zafar Agha of Qawmi Awaz, Paresh Nath, Anant Nath and Vinod K. Jose of Caravan. The FIRs were filed against the accused alleging that they had indulged in inciting people to violence with a misinformed reporting concerning the tractor rally violence of the capital. There are legal precedents which cover this issue. We will issue notice, said Chief Justice of India S.A. Bopde, when the cases were called on for hearing. So what to expect in the next hearing? Even though there is a stay on the arrest of the accused, the authorities are not barred from carrying out investigation. This means that when the cases are taken up after 2 weeks, the court is expected to hear arguments on the quashing of the FIRs at length. The Supreme Court has recently issued notice in a petition by the centre seeking transfer of cases pending across high courts for regulation of over-the-top platforms like Netflix, Prime Video, Disney Hotstar, etc. The main contentions of the petitioner as raised in the petition revolves around setting up a regulating body, licensing, censorship and availability of pre-screening remedy. According to a new amendment in the Government of India Allocation of Business Rules 1961, these OTT platforms along with content on current affairs and digital news will all be regulated by the Ministry of Information and Broadcasting. Let's have a look at some important Apex Court judgments for the week. A division bench of the Supreme Court dismissed all objections to the winding up of 6 mutual fund schemes floated by Franklin Templeton and upheld the results of e-voting. The bench precisely said, "We hold that for the purpose of Clause C to the Regulation 1815, consent of the withholders would mean consent by majority of the unit holders who have participated in the poll and not consent of majority of all the unit holders of the scheme. We reject the objections to poll results and hold that the unit holders of the 6 schemes have given their consent by majority to wind up the 6 schemes." The Supreme Court has held that once the signature of an accused is established on a check, the onus to prove otherwise rests with the accused himself. A full bench judge said, considering the fact that there has been an admitted business relationship between the parties, we are of the opinion that the defense raised by the appellants does not inspire confidence or meet the standard of preponderance of probability. Court further placed reliance on Bir Singh versus Mukesh Kumar, wherein the Supreme Court had said, even a blank check leaf voluntarily signed and handed over by the accused, which is towards some payment, would attract presumption under Section 139 of the Negotiable Instruments Act, in the absence of any cogent evidence to show that the check was not issued in the discharge of a debt. The Supreme Court has observed that the embargo stipulated in terms of Section 10A of the IBC must be given a purposive interpretation. The top court, while dismissing the present petition and acknowledging the legislative intent behind Section 10A IBC, said, acceptance of the submissions of the appellant would defeat the very purpose and object underlying the insertion of Section 10A, for it would leave a whole class of corporate debtors where the default has occurred on or after 25th March 2020 outside the pale of protection. High Court updates and other legal news of the week commencing February 7, 2021. The Delhi High Court refused to quash the FIR filed by the complainant, a Hindu girl. The accused had falsely misrepresented himself to have the name Shiva instead of Akhtar, developed a physical relationship with her and married her. In the present case, the lady became intimate and married the accused, who concealed his identity from her. When the complainant got to know the accused's real name, she lodged an FIR. The Delhi High Court has observed the central government should consider relevant factors while declining its consent for premature release of a convict. Justice Vibhu Bakru emphasized that although the powers conferred under sections 432 and 433 of the CRPC are discretionary, it is well settled that wherever discretion is conferred, the authority on which it is conferred must exercise it if the purpose for which such power is granted are met. The Madras High Court has observed that the power to issue a writ of mandamus to interfere at a pre-detention stage must be exercised only in exceptional circumstances. Article 226 of the Constitution empowers the High Court to exercise its writ jurisdiction even at a pre-detention state, where the court finds that there is a threat of potential violation of the fundamental rights under Article 21 of the Constitution. This court, in order to satisfy itself that there is a potential threat of the violation of Article 21, must have some materials before it. In other words, it cannot be based on mere apprehensions, and this court can only act on some overt acts, Single Bench of Justice N. Anand Venkatesh noted. Madras High Court has observed that just because a man and a woman were found locked inside the house, there cannot be a presumption of illicit sexual relationship. Assuming that the petitioner had allowed the co-employee to be a woman-folk at his residing place, it cannot be automatically presumed that such entertainment of an opposite-sex co-employee is only for immoral or illicit activities. Unless there is strong and concrete evidence to suggest that the illicit or immoral activities had taken place, merely based on presumption or surmise, one cannot conclude that since they were under one roof for some time, it is only for illegal activities. This kind of a presumption alone in the society cannot be a basis for concluding as arrived by the disciplinary authority, that too for inflicting the punishment against the employee working under him. Single Bench of Justice R. Suresh Kumar observed. In a complete about turn, actress Kangana Ranaut told the Bombay High Court that she would be approaching the BMC to regularize the illegal constructions in her Khar-based residence. The High Court has now allowed her to withdraw her plea before it and approach the civic body. Notably, Kangana had claimed that there were no illegalities in her flat, but on Thursday, she told the bench of Justices Prithviraj Chavan that she would rather file an application before the BMC and seek regularization of the same. So that's all for the week, folks. We'll see you next week. Bye.